Hello everybody, my name is Joe Hardgrave and I am the supervising attorney for the Indian Law Practice Group at Montana Legal Services Association. I work out of our Helena office and I'm presenting on the drafting of Indian wills today. A little bit about me and my background and why I'm teaching this. Montana Legal Services Association had an Indian wills project years ago. And we had how I started my career back in 2008. I was an AmeriCorps legal fellow, and we had what we called the Indian Wills Project. We had this for several years, where all I did was drive around to all the reservations in the state and wrote wills and gave presentations on the American Indian Probate Reform Act. And it was a great job. It was a great resource that we had at Legal Services. However, that position is no longer there, and that went away a few years ago. Now I'm primarily serve as the public defender at Fort Belknap and take civil cases in Belknap and Rocky Boys and other tribal courts. And I'm essentially a full-time litigator. But doing Indian wills is how I started my career. They are important to me. I have a passion for doing them. And Legal Services has just recently expanded our services to draft more wills. We don't have the same Indian Wills project we had before, but we do have capacity to do will drafting now. And so we are once again trying to draft as many wills as we can. To get started, so why are we talking about Indian wills? Why are Indian wills important? And it all started with the APRA, the American Indian Probate Reform Act, which was enacted in '04 and became effective in 2006. So it's still a relatively new law, but as you've learned, APRA was designed to address this issue of fractionation, which are these small trust allotments that many Native people own they're just very small, decimal, like 0.0001% sometimes interest in a trust allotment. So this federal law, APRA, was passed to address this issue of these very small interests that are unwieldy and difficult to do much with or to become profitable. So much of APRA's design is to address this issue, and many of the rules that when you don't have a will, for instance, the single heir rule, which a lot of people have heard, if you have a smaller than 5% interest and you don't have a will, that will go to your oldest child, which is kind of a harsh provision. People have heard of this rule, but its purpose is to address fractionation, as you can see. If they want to try to keep these smaller interests together, because as opposed to what happened in the past, where over time they would just be divided amongst all the children and go according to state probate laws. So over generations, this issue of fractionation developed. APRA is here to address that issue, and it's also, APRA is considered a will-friendly law. The law wants to encourage people to draft wills. Another example of how APRA addresses fractionation is the joint tenancy assumption, which I always thought was odd. But what it says is, if you use this old language that are often in wills, like share and share alike, and you don't specify, that will be considered a joint tenancy with right of survivorship, which we'll cover a little bit more exactly what that means here in a minute. One of the most important things to remember about APRA and when you're drafting a will is who can inherit trust land. APRA has the most expansive definition of Indian under any federal law. And as you know, the definition of who is an Indian, it depends on what federal law you're looking at. Under APRA, it's one of the most expansive out of all of federal law. And it says, and this is important because when you're drafting a will and you're figuring out if your client can devise trust property to whoever these beneficiaries are, they have to fit under this definition of Indian. It's extremely expansive and includes any lineal descendant. So that's any child, grandchild, great-grandchild can inherit trust land, and regardless of their actual status, regardless if they're enrolled, not enrolled in a particular tribe, they're considered a lineal descendant under the definition. So what I found in my experience in drafting all the wills that I've drafted, most of them are fairly simple. You don't have to refer to APRA that much. If you know the person is considered Indian under the APRA definition, then they can inherit trust land and you can include them in the will. If someone is actually not Indian under APRA, they can still inherit, but we would use a life estate, and they can inherit a life estate, which we'll talk about more in a minute, with the remainder going to someone who's Indian under that definition. When you're first advising your client, in the beginning of the process of will drafting is meeting with the client, seeing what it is that their wishes may be for their land and how they want it to pass, and discussing with them the various options they may have. They may not know that about life estates or the option of you doing a joint tenancy. But you also want to talk to them about ways to consolidate their interest. Because, for instance, if someone has 5 children and they just give everything to the 5 children equally as tenants in common, it'll split up that single interest into fifths, and it'll be much less, you're creating more fractionation that way, essentially. Now that may be what that particular client wants. And like I like to say, the client is the boss. Ultimately you do what the client wants, but you want to have a discussion possibly about ways to consolidate and keep these interests nice and tight and full. And so you have this discussion that one of the best ways to facilitate consolidation is to take a single interest and give that to a single person. That is, in my opinion, the best way to do it. You keep the whole interest intact. What makes that difficult for some people, though, is that there may be no way to make that totally fair between all the children. If you have multiple children and you're trying to split them up in some way that's more fair, there'll be no way to perfectly balance all these single interests. You just get as close as you can. But if you're more concerned, if the client's more concerned about fairness and everything being totally equal, you're going to have to go with a joint tenancy or a tenancy in common and split it up that way. And then you'll have that discussion that if you do a joint tenancy with right of survivorship, that's a way to keep the interest intact in the end. Because if you remember, the way that the joint tenancy with survivorship works is, say you have 3 children and you're giving it to those 3 children. They each get a third of that interest, but the first one to pass away, that interest goes to the remaining 2. So that someday down the line, the interest will consolidate down to that one person that's left. So that's another way to help facilitate consolidation. But you can also use the tool of a life estate. Oftentimes people come to you and say they want to keep the land in their family forever, which the law doesn't allow. The law doesn't look favorably upon that. It calls it dead hand control. I usually explain to clients that you have to understand that you're a property owner and you have these rights, but when you give property away, that person inherits those rights and can do what they want to with the property. So you can't keep land in the family forever. But what you can do is a joint tenancy or a life estate to maybe keep the land in the family, at least for a generation or two. One thing I do tell people if they feel very strongly about this is I'll put that language in the will. Always remember you can put language into a will even if it's not legally enforceable. You just explain it to the client, this is not legally enforceable, but at least your wishes will be known, so I'll put this into the will. Something that you'll also have to often explain to clients is this idea of an undivided interest. It's difficult to wrap your head around initially, because when you're explaining what an undivided interest is, let's say, for example, you take a 100-acre allotment and the person owns 10% of that 100 acres. Naturally, you want to say you have 10 acres, and that's what your mind wants to do. And the person wants to say, I have 10 acres. My 10 acres are right here in the corner of this parcel. They want to parcel it out. You have to explain to them that no, that's not what an undivided interest is. An undivided interest means you own 10% of the whole 100 acres, and it cannot be divided. And the person may possibly own with 100 or 200 other co-owners, which is why fractionation is the problem that it is it's so unwieldy and hard to do anything with these interests when there's so many co-owners and such small interests. But you have to explain to your client what an undivided interest is. One of the best ways to identify a person's trust interest is through what we call an ITI report, Individual Trust Inventory Report, that you can receive through the Bureau of Indian Affairs. Every reservation in the state of Montana has a local BIA office, and you can go into the BIA and request an ITI report, and they'll print it right off for the client, if the client's there in person. And that is, the BIA has a ton of different reports, but the ITI is the easiest one to read. And it lays out exactly every interest that the person owns. And it identifies everything that you need to know to write the will and to include that interest in the will. What we have here is an example page of an ITI report. And what you're seeing here is a single an interest that this person owns. There are a lot of different numbers here and a lot of different things on the ITI report. What I want to point out, the most important parts of the report are these numbers right here are the numbers these under what it says as tract ID. These are the numbers. These are very important because these are the numbers that you use to identify the allotment in the will. So for example, if I was writing a will that includes this interest, I would identify it using this number, the LAC number 204, a prefix of M. We don't have, we just have zeros there for numbers, and then the suffix as well. So this would be interest 204M0000 negative A, located in Belknap, Montana. And that's how I would identify that in the actual will. There's a lot of other information on the ITI report that's important for your client. Sometimes you explain to them, you look at this numbers down here in the bottom right hand corner, and that tells you how much they own of the interest. So this person owns, you move the decimal over 2 spots, 0.297% of this acreage, 280 cumulative acres. And that explains to the person how much of an interest they have, the size of their undivided interest. Those are the most important numbers of the ITI report. So as I was saying, how should you include a trust interest in a will? Here's an example of how I would write it out. Now this is just how I would write it out. It doesn't mean, APRA doesn't tell you exactly how to write it out. And in a lot of things with will drafting, it's up to you to decide what language you use, what you think, in using your own judgment, will be clear enough to the person reading it, what you're describing. I describe it as Blackfeet Allotment 201-249, located in Glacier County, Montana. I recently had someone say, all you need to do are these two numbers. So for example, that would suffice. I mean, there's no legal requirement that you have to have certain words in here. You just want it to be clear to the person that's reading it, the judge, what allotments you're referring to. That brings me to one of my main points of the entire presentation. What is the most important thing about writing a will? What I always tell people is that the will is clear. A simple, clear will is the best will. That's the most important thing. You want to be able to say, when the BIA judge is reading this, that they're going to understand it and they're going to know what it is the person wanted to happen upon their passing. So that's the principle throughout this whole presentation, that the will is clear. You don't want to be too complicated, too complex in a will. You don't want too much language that's indecipherable. You want to be perfectly clear. So we have a example of a will. This is a template that originally came from University of Seattle School of Law. They were considered the experts on Indian wills back in the day. And this is the form that I've been using. And at the beginning, very, very typical of a will, we identify the testator or testatrix. I like to we include a BIA enrollment number in there. Then we have some common language. I, Jane Doe of the Grovant tribe, sound and disposing mind, realizing the uncertainty of human life, not acting under any duress, menace, fraud, or undue influence, hereby make and publish, declare this to be my last will and testament. Very standard language. We have an article that revokes all prior wills. As you may know, when you do a will, that automatically revokes any prior wills. It's good language to have. Even if a person doesn't have a prior will, we often just leave that in there. The next section in the will template is the identification of family. This is a very important section of the will. The reason why is because the person may not want to devise or give their property to all these members of their family. They may want to disinherit somebody, which of course is their right. That's why they're writing a will. You get to decide who you give your property to and who you don't. But this is an important section because say you want to give some of your property to one child but not the other child, you want to make sure you identify both those children in this section. So it doesn't appear to anybody that you just forgot this person or just left them out accidentally. So you want to include in here, under the identification of family, as much information as you can about your family, about your spouse, your married situation, which are these different scenarios, whether you're divorced, you want to include this information. Whether you're widowed, we have language for every step of that situation. Then we go into your children. What I like to do for naming people's children is I like to include their birth date and enrollment number and mention what tribe they're enrolled in. This information is not required by APRA, but I think to be complete and be diligent and to help the BIA probate judge, this is what you want to have in here. You want to describe the situation, whether they're enrolled, enrollable, those type of scenarios. You want to include that. Then we have some language if they have deceased children. We have language to cover a guardian or someone who has been adopted. Here's some adoption language that we have in the form. You also want to try to include grandchildren and great-grandchildren, if at all possible. Now, some people may have a lot of grandchildren, great-grandchildren. Just use your own judgment there. Then the next section we have is the personal representative section. This is another important section of the will. It's somewhat unusual because in the BIA form, which is where the will is going to be probated, it's going to be probated with the BIA is going to have jurisdiction over the trust land. Now, there may be other probates. There may be a tribal court probate or a state court probate for other land. The BIA is only going to deal with the trust land. In the BIA forum, technically the federal government is your personal representative, so you do not have one. However, we like to include a personal representative in our will anyway, in case it is probated tribally or through the state. And we just think it's a good practice to include a personal representative. So we have a section with language for, now a person doesn't have to name a personal representative, then you just explain to them one will be appointed if there's a tribal or state probate. Now we get to the most important section of the will, which is their trust land. We have language here for every situation for a single beneficiary, which is the most simple way, and the way I discussed at the beginning to keep a allotment intact. You just go from one allotment to one beneficiary, and here's the language that we have. Now, we have the two situations. This is specific allotments to specific people, which, as I explained, is the ideal way to keep interest together and from fractionating. But now we have some language for joint tenancy with right of survivorship. You want to be very, very clear in this language. This is one of the most important parts of the will, and you want the language to be perfectly clear whether the person wants a joint tenancy with right of survivorship and use those words, or whether they want a tenancy in common. A tenancy in common, remember, is the interest is split up amongst the beneficiaries and they can do whatever they want with it. This is often what clients pick because it seems to be the more fair option as far as their children can then, they can devise and their interest to their children and so on. With the right of survivorship, you can't sell or devise your interest because there's that survivor that's going to have that interest. So we have language for either way of splitting interest up through the joint tenancy or a tenancy in common. And just be very careful with language in that section. The next section is titled Trust Personalty, which is a phrase meaning your IIM account, individual Indian money account, which if a person has trust interests that are producing income, which is common from leasing, grazing leases, all sorts of leases from the BIA, then some money may go into that IIM account. If you own trust interest, then you have an IIM account. Well, you can devise in your will who gets that money. And it's also considered in trust. It's kind of a strange legal anomaly because it's only money, so it doesn't matter if it comes out of trust. And you can actually put a non-Indian in this section and name them. But one distinction you need to realize here is that there may be money in that account at the time the person passes, and that's what you're naming in the will. But there will also be money that accrues because these probates take a really long time through the BIA. And what often happens is money accrues in these accounts from the time the person passes till the time the probate is actually final. Sometimes that can be a lot of money. That money will go where the interest, whoever is inheriting the interest that produced that income is going to get that income that accrues. So the income that accrues is different than the income that is in the IIM account at the time of passing. Something to keep in mind about trust, personality, and dealing with IIM accounts. Now we have a section that in our experience people like. It's devising property through a separate writing. Now what this means is this section will allude to another piece of paper that's going to be with the will. And you explain to the client, well, first you have to explain what personal property is, which can be anything from jewelry, clothing, furniture, to vehicles. But what this does is this allows that person to make their own list. Write out the property, who it goes to, sign it and date it, and keep it with the will. And it's considered part of the will and incorporated into the will through the language we have in this Article 6. Now, a person doesn't have to do a list, and that's what I explain to clients is if you don't do a list, it will just fall back to the residue or residuary clause that we'll talk about here in a minute. But it's a great option for clients if they want to just write out, they have a lot of personal property that they want to deal with. We also have a section if they have real property, if they have a home. Now remember, there was a lot of confusion over the years whether a home was considered in trust or not. It's not. The BIA is not going to deal with the home, but if a person has a home, you definitely want to include that in the will, and you want to include it in this section of non-trust property and give a legal description of the property and carefully deal with the home. Now here's an example of someone if they don't like the idea of using a list in that section before and they don't want to write it out on their own. Here, this is also a section where you can include personal property. Now we get to the residue or residuary clauses. What these are a catch-all provision in the will for land and property that's not accounted for. For example, it'll say everything that this person has that wasn't listed before, I want it to go this way to this person. And this is a very important part of your will because people often inherit trust land. It's frequent, it happens all the time. So I often tell people, consider this section important because you could inherit land tomorrow after you do your will. Your will doesn't account for it. Who would you want that to go to? And that's where the residue clause comes in. And you can do multiple beneficiaries. You can set up your residue, your residuary clause. What often happens is it mirrors the trust land section that you did before. But you can come up with other ways to deal with the residue. There's a section for a guardian. If you have minor children, you want to include that. There's a section for burial. Now, what I tell people about burial is I often don't include that in the will because you need to explain to your client that sometimes wills are hard to find. Sometimes you don't find the person's will, and so you don't want that person's burial wishes to only be in the will. I tell them to tell their personal representative, tell somebody what their wishes are. In case you can't find the will, someone will know what the person's burial arrangements were. Then we have a standard invalidity clause. And then once you're drafted, it's time to execute the will. What you want to do during the execution, of course, is make sure that the testator is competent. Let me say a little bit about competency. The competency to do a will is the lowest level of competency under the law. What I mean by that is the person doesn't need to know much. All they need to know is what property they have and how they're giving it away in the will. And if they know that, they know enough to do a will. So for example, even if someone is diagnosed with dementia and they have a hard time comprehending things, if at that, they can have what they would call a lucid moment, and if they are executing a will and at that moment know what property they have and how it's going to go, they're competent enough to execute a will. Of course, I would want to document that very clearly if the person does have dementia, because what tends to happen is a lot of clients are concerned about who's going to challenge my will. And clients bring it up all the time. They'll say there's so-and-so is a troublemaker in the family. They're going to contest this will. Is there any way I can keep this person from contesting this? And you have to explain to your client, no. The person always has a legal right to make a claim that the person is either incompetent that did the will or they were unduly influenced. But you further explain to your client that those are very difficult claims to prove. The burden of proof is on the person making the claim, and the folks that wrote the law realized there may be a lot of challenges to wills. We don't want it to make it very easy, so it's not easy to do. There's no way to keep someone from making the claim, but the safest way to protect from it is to have a perfectly clear and simple will. That's the best way to keep yourself safe, and that's what I explain to clients. But to execute your will, you show the testator's competency. You need 2 disinterested witnesses, which means disinterested just means they're someone who's not actually taking property from the will. We have a self-proving affidavit we use, which requires a notary. That's not legally required, but it's an extra step to take, which is good to take. Then you have to talk to the person about what to do with their will. The BIA, used to draft wills and store them back before 2006. Now they no longer take wills. It's our practice to give the person the original will. So you have to explain to them how important that is and ways to safekeep it. You explain to them that it's the original will is the only one with real legal effect. The one with their ink on it is the important one. They always ask, should I make copies? And you can say yes, you can make a copy. The judge is not going to accept a copy unless it's some extremely rare, exceptional circumstance. So you advise the client of the importance of that original, to keep it in a safe place, to let someone know where it's at. That's a common issue, is not being able to find these wills once the person has passed. And also explain to your client that they can revoke the will at any time, or they can amend it. They just have to, revoking it is as easy as saying, I revoke this will and tear it up, and then it's revoked. I wouldn't recommend doing that unless you have something else in place before you do that. I consider my job at Montana Legal Services as support and guidance for folks in the state writing wills. I want people to call me that are writing these wills in the state that have any questions or concerns or any particular situations that they need help with. I want to make myself available as much as possible. So if you're writing a will out there and you come across a situation that you don't know how to address, please give me a call. Give me a call, email me, get in touch with me, and I'll be available. So thank you.